It is 7 o'clock in the morning. You have been traveling for 14 hours. You are exhausted. Your bag is heavy, and all you want to do is get through the airport and go home. You walk up to the CBP officer at the booth. You slide your passport under the glass, and everything feels normal. Then the officer looks at his screen. He does not hand your passport back. He types something. He picks up a phone, and then he says those 4 words that make your heart stop. Please come with me. You are taken to a room in the back. The door closes. Another officer sits across from you, and he opens your file on his screen. He looks at you and says, "I need to see 5 years of bank statements." And in that moment, you realize you have nothing. You have no documents. You have no records printed out. You do not even know why he is asking. And while you are sitting there trying to figure out what to say, the clock is already running on a process that could end with you on a flight back to your home country before the sun goes down, with a 5-year restriction placed in your file and no hearing, no judge, and no second chance. This is not a hypothetical. This is happening to real visa holders and green card holders right now at airports and land ports across the United States. And if you do not know exactly why it is happening and exactly what to do, you are at serious risk. Let me tell you what most people get significantly wrong in this situation, because this is where the challenge is. And it is a challenge that has already affected thousands of people in their status, their careers, and their lives in America. When a CBP officer asks for financial documents at the border, most people do one of 3 things. They become anxious and start talking too much, volunteering information they should never have said. They become defensive, which the officer reads as concerning behavior. Or they say nothing useful because they simply never prepared, never thought this could happen to them, and assumed that having a valid visa meant that the difficult part was over. All 3 of these responses can accelerate the path to what is called an Expedited Removal Order. And if you receive one of those, your situation changes instantly and dramatically. Under an Expedited Removal Order, or ERRO, you are denied entry to the United States on the spot. Your visa is canceled immediately. You are placed on a direct flight out of the country, typically within 24 to 48 hours, and you are barred from re-entering the United States for 5 years. There is no immigration judge. There is no court hearing. There is no appeal process in the traditional sense. The officer who questions you is also the officer who issues the order. According to legal guidance published by immigration law professionals and confirmed by CBP's own operational framework, this process is fully legal, fully in effect right now, and fully applicable to H-1B workers, F-1 students, B-1 and B-2 visitors, green card holders returning from abroad, and virtually every other immigration category you can think of. The decision rests on the CBP officer's determination in that moment in that room that you are inadmissible. So the question is not whether this could happen to you. The question is whether you are prepared. Now let me give you the legal framework you need to understand, because knowledge is your protection. Under the Immigration and Nationality Act, specifically under Section 212, a person seeking admission to the United States must demonstrate that they are not inadmissible on any of the listed grounds. One of those grounds found in Section 212A4 is the public charge ground. This means that if a CBP officer has reason to believe you cannot support yourself financially while in the United States, or that you are likely to become primarily dependent on the government for support, that officer can find you inadmissible. Financial documents, including bank statements, are one of the key tools CBP uses to evaluate your ability to support yourself. This is not new law, but what is new is how actively and broadly it is now being applied. Since January 20th, 2025, recent administrative directives have significantly expanded the enforcement posture of CBP and ICE at ports of entry. Officers are now operating under explicit guidance to conduct more thorough financial and biographical vetting during admissions interviews, especially during secondary inspection. And because of the biometric entry-exit final rule that went into effect on December 26, 2025, every non-U.S. citizen's face is now matched against government databases the moment they approach a CBP booth. If that match pulls up any indicator in your record, any discrepancy, any gap, any prior immigration issue, the likelihood of secondary inspection goes up significantly. In secondary inspection, the officer has broader authority, more time, and more tools. And under CBP Directive 334049A, they can legally search every app on your phone, including your banking apps, payment apps, and any financial records that are visible on the device. This is the environment you are walking into every single time you cross a US border. Right now, here is where I need to stop and address something that is spreading like wildfire on social media, on TikTok, and in messaging immigration groups because it is inaccurate and it is wrong. There is a claim circulating right now that says CBP has no right to ask you about your finances, that only USCIS can evaluate financial eligibility, and that requesting bank statements at the border is an improper overreach. This is completely false. CBP has full statutory authority under the INA and under DHS regulations to evaluate financial admissibility at the port of entry. There is another claim going around that says if you have a valid visa, you cannot be denied entry for financial reasons. Also false. A visa is an authorization to travel to the United States to seek admission. It is not a guarantee of entry. The CBP officer at the port of entry makes the final admissibility decision, and that officer is not bound by the decision of the consular officer who issued your visa. I have seen people in comment sections telling others that they can simply refuse to answer financial questions by citing constitutional protections against self-incrimination. As a non-citizen seeking admission at the border, you do not have the same constitutional protections as someone already inside the country facing criminal prosecution. Refusing to cooperate with a CBP admissions interview is in practice treated as a failure to establish admissibility, and that failure can and does result in denial of entry. These misconceptions are not just wrong, they are risky. Following that advice can put you in an expedited removal order within hours. Now, let me give you the action plan because this is the part that will actually protect you. Tonight, after you watch this video, here is exactly what you need to do. First, pull your bank statements from the last 5 years right now. Log into your bank's online portal. Download your monthly statements going back 60 months and save them in a clearly labeled folder, both on your device and in a cloud storage account you can access from anywhere. If you bank with multiple institutions, do this for every account. When a CBP officer asks you to demonstrate financial stability, you want to be able to show a clean, consistent financial history. You want to show regular income deposits. You want to show that your balance is adequate for your intended stay, and you want to show no concerning large cash transfers in and out of the account. If your statement history shows irregular patterns, get in front of that by preparing a simple written explanation for your records. Second, print and carry a physical copy of your most recent 3 months of statements every time you travel internationally. Yes, physically printed. CBP officers have documented authority to search your phone, but they cannot compel you to unlock cloud accounts or remote servers. Having physical documents ready signals that you anticipated the question, that you have nothing to hide, and that you are a prepared, organized traveler. That alone changes the energy of the interaction. Third, know your admissibility profile before you travel. Log into your I-94 record at the official CBP website, which is i94.cbp.dhs.gov, and confirm that your previous entries and exits are accurately recorded. If you see any discrepancies, address them before your next international trip, not during a secondary inspection when it is too late. If you have ever overstayed a visa, had a prior removal, or had any issue at a U.S. border, speak with an immigration attorney before you travel. These indicators will appear in the CBP system the moment your biometrics are scanned, and an unprepared traveler with an indicator in their record is exactly the profile that gets sent to the back room. Fourth, if you are a lawful permanent resident, meaning you hold a green card and you travel internationally, you need to carry evidence of your ties to the United States in physical form every time you cross the border. This means your most recent tax return or tax transcript, your employment records or pay stubs from the past year, evidence of your U.S. address, such as utility bills or lease agreements, and ideally a letter from your employer confirming your ongoing position. Green card holders can be sent to secondary inspection just like any other traveler. And in secondary, the question of whether your residence in the United States is genuinely continuous can come up. Bank statements from a U.S.-based account showing consistent U.S. activity over multiple years are one of the strongest pieces of evidence you can present. Fifth, if you are ever placed in secondary inspection and a CBP officer begins asking detailed financial questions, here is exactly what to say and how to say it. Be calm, be direct. Do not over-explain. If the officer asks where you work, you say clearly, "I am employed by," and you give the name of your employer and your job title. If the officer asks about your finances, you say, "I have my bank statements available if you would like to see them," and you present the physical copies you prepared. If the officer asks a question you genuinely do not understand, it is fully appropriate to say, "I want to make sure I understand the question correctly. Could you please clarify?" You are not being evasive. You are being precise. What you should never do is volunteer information that was not asked for, because in a high-pressure secondary inspection, extra information almost always creates more questions, not fewer. Sixth, and this is critical, if you are issued any document during a secondary inspection, whether it is a sworn statement, a summary of the interview, or any form with your name and case number on it, keep every single copy. These documents are the foundation of any future legal review, any request for reconsideration, or any waiver application. According to guidance from immigration law professionals, errors and misinterpretations by CBP officers do happen, and a written record of what was actually said is essential if you need to challenge a decision. My name is Mark. I am a senior immigration analyst with 6 years of experience. And on America Door, I do not give you opinions. I give you the information strategies that help families stay together. What you just heard is not meant to frighten you. It is meant to prepare you. Because the border environment in 2025 has become more stringent than it has been in over a generation. And the people who get through it without incident are not the ones with the most expensive attorneys or the most powerful visas. They are the ones who showed up prepared. Immigration rules change frequently. Join my messaging community for instant alerts before I post on YouTube. The link is in the description below, and I want you in that group before your next trip. As a reminder, everything covered in this video reflects information as of the date of publication based on official CBP, DHS, and INA frameworks, as well as analysis from immigration law professionals and advocacy organizations. This content is for informational purposes only. It is not legal advice. For your specific situation, please consult a qualified immigration attorney. Policy changes can and do occur. Always verify with official sources before you travel. If this video helped you, like it right now and share it with every visa holder and green card holder you know. It could be the most important thing they watch this year. If you want accurate, timely, and reliable immigration updates, subscribe to America Door right now and turn on notifications. Staying informed is no longer optional. It is essential. I am Mark. Protect your status. Protect your family.